Welcome to All Things Financial with Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. What we're doing through this show, I have an attorney on that's agreed to be a guest for a couple shows in a series here. Matt Carl, appreciate your coming back on the show as a guest.
Well, I appreciate it, Jack. I've been having fun.
What we're trying to bring to you listeners and viewers are some of the areas in which we need the help of an attorney, or we need to start thinking about areas other than our day-to-day lives. And one of those areas over the last 2 weeks and 2 shows has been general estate planning. Matt's agreed to come on today and talk to us and you business owners. We have special needs, we have special problems, and we have multiple sets of problems and circumstances that are not the same as some individuals and married couples. Isn't that right?
Oh, absolutely, absolutely. A business is an entity in and of itself, and it doesn't necessarily die when you do. And so if you don't address what you can do with a business upon your death, you got some problems that you left to your spouse or to your family. So part of any good estate plan deals with business interests that you may own during your lifetime.
And I guess the beginning of every story is the beginning. And in most businesses, the beginning is, how did we start into the business, and how did we first form or set the formation of the business? A sole proprietorship, an LLC, a partnership, a C Corp, an S Corp, and all of those then were affected by that initial decision, which seemed so simple for a lot of different areas. So what do you have to say about the different formations of businesses?
Well, it's probably the simplest and the obvious first business was a sole proprietorship, and that's where an individual owns the assets that operate his business or her business in his or her name alone. And these assets are therefore done through Schedule C, depreciated, things of that nature on your 1040 for your tax return. It's probably the simplest form of business, but probably the one that is not recommended by most attorneys, primarily because when you own assets in your own name and something bad happens, then you get sued in your own name.
Okay.
And when you get sued in your own name, not only are they able to go after the assets that you use in your own business, but also assets that you use recreationally. Perhaps your home, if you don't have it owned jointly with a spouse. If you own your house with your spouse as a tenant, and by the entireties we call it here in Pennsylvania, they can't get after the house. But they can get your car, they can get your truck, they can get your savings accounts that are in your name alone. So generally we shy away from the sole proprietorship except in some rare cases. The second type of business that you did mention, Jack, is a partnership. Now, a partnership is a sole proprietorship where two people got together and decided that they were going to do some type of business together. Partnerships are very similar in terms of liability as sole proprietorships, though, because if you're a general partner in a general partnership, not only can they go after your assets that are in the business individually, but also the assets of your partner.
Oh, boy.
Yeah, so in very rare situations do we put people into general partnerships. General partnerships do have a spin, and that's called a limited partnership. And a limited partnership is an organization where there is one general partner who controls the operation of the business, and the rest are limited partners who are primarily investors and have very little say in running of the business.
Okay.
Those are done quite a bit in some real estate deals and things of that nature. And in order to insulate the general partner from the liability, because the general partner is the only entity that has the liability in a limited partnership, generally we make the general partner another business entity so that he's not an individual or not a general partner as a general partner, if that makes any sense.
Yeah.
So those provide. So now we're talking about an entity that provides a limitation on what you invest as the sole amount of what they can get if things go wrong.
Okay.
And as you know, in the real estate business, since 2008, some things did go wrong.
Yeah.
So it was good to have things in those situations. Corporation is one of the oldest forms of protecting investors from liability, but also permitting them to be involved in the management of the business, either through the board of directors or being an officer of the business. So they were kind of the original entity to promote business. And actually, the formation of charters back when the New World was discovered was the origination of corporations where people could insulate themselves from personal liability. So they have been quite common.
Yeah.
Now, the tax consequences on corporations, though, have been adverse, as you might be reading in the newspapers, in that they have a two-tier of taxation. First
Right.
of all, the corporation as an entity itself is taxed, and then when it distributes dividends, or in other words, profits, to its shareholders, the shareholders pay a tax on it. Well, they tried to address that. They did address that situation back in the 80s with what we call subchapter S corporations, where specific corporations that have a small number of shareholders can make an election to say, we will treat ourselves as, the sole taxpayer. There's special subchapter S rules and things of that nature that affect your decision whether or not you want to make that election.
Okay.
That's why I've said in previous shows that part of any good team, particularly on a business team, is having a good CPA who will help make you decide what is the best election to be taxed by.
Okay.
The last one, and I used to teach this course up at Duquesne to paralegals, is the limited liability company. The significant one. There are others, but we'll just talk about that.
Okay.
It's been like the modern thing.
Yeah, it is.
Yeah, and the reason it is because I used to tell my students it's protean, which is a Greek monster that I think it was Hercules, when he would wrestle it, it would change shapes. It'd be a snake at one point, and then whenever you get the snake by the throat, it'd turn into an eagle, things like that. And so an LLC is similar to Proteus in that you can make it almost whatever you want to make it. You can make it look like a limited partnership and run like a limited partnership.
Okay.
You can make it like a corporation with officers and directors. Or you can just make it so it's member managed. They don't use shareholders. They call them members of an LLC.
Okay.
And so these LLCs are quite flexible. You can elect to have them as taxed as partnerships. You can elect to have them taxed as corporations or sub-S corporations.
Okay.
You can't elect to have them taxed as sole proprietorships unless you are the sole member of the LLC.
Okay.
So those are the basic entities that you would choose from.
Regardless of how you direct they're going to be taxed, does the LLC still provide the legal protection of the members' assets, whether you're taxed as a sub-S or a partnership or a corporation?
Yeah, actually, that's a very good question, because I didn't bring up the issue of charging orders, okay? In a corporation, if the corporation does something wrong, there's judgments entered against it, it doesn't pay its debts, things of that nature, and judgments entered against it, then they can go to the corporate assets. The sheriff literally will go in, levy upon them, and sell them, okay? In limited partnerships and in LLCs, if you get a judgment against the LLC or the limited partnership, and the real estate is sitting, or business assets, machinery, trucks, whatever, they put what is called a charging order on them, and the charging order is something that doesn't say you can sell the assets, but what you can do is, to the extent the partnership or the LLC distributes income, you get the income. Makes it much less attractive to a creditor because obviously, you're counting on a stream of income instead of a bulk sale.
Right.
Now, recently the law has changed with single member LLCs in that the single member LLC is now treated that you can go in and sell the assets of the LLC instead of using a charging order.
Okay.
So as people come in and they say, well, we want to be a single member LLC, we have them consider maybe having, a spouse or a child or somebody taking an interest for that liability purpose.
Okay.
But, there's also the estate planning side of organizing all of these things.
Yeah.
Because as we know, typically when businesses start off, they're more of a liability than they are an asset.
Yes.
And until that sweat equity is put into that business, it's not worth a lot.
Right.
And the best time, if you have estate planning issues or you don't want to have an asset go through the taxation process, whether it be federal or Pennsylvania inheritance tax, upon your death, you may want to have children involved as owners in the business, but not necessarily as managers.
Okay.
So if in fact that's a goal, we set up, either trust for children, in which the parents are the trustees.
Okay.
Or, some other type of family entity, like family limited partnership or something, where the limited partners are the children, and they'll have an ownership interest in something that started off at a very low value, but maybe by the time of the father or mother's death might be worth a heck of a lot of money.
Okay.
That does not even go through probate under their estates because they're already owned by the kids.
Oh, that's good.
Yeah. So, when setting up an organization, we do have to take a look at, what your ultimate goal is, as well as what your estate planning needs are. Oftentimes, attorneys don't do that. And so you run down one track with one thing, and then you run down another track with the other thing, and oftentimes the two tracks don't come together, and you run into a mess when the owner passes away.
Okay. Now, the subchapter S versus the LLC taxed as a subchapter S, is the asset protection different, did I hear you say? One on the LLC, they can still make a claim against the income. How does that work on the subchapter S itself?
On a subchapter S corporation, they sell the assets. They liquidate the assets on a judgment.
I see. So the LLC has different, but also apparently better or potentially better asset protection than the... Okay, got it.
Sure.
Very interesting. Yeah, very interesting. What do you do when you run into these business owners who begin starting to think and their businesses are expanding and they are getting more valuable, or their family and situations are getting more complex, or they're just aging and getting closer to thinking about what happens to the business when something happens to me? What then?
Well, the ideal situation is if you have a good buyer and you can get a good price, you sell it.
Okay.
Yeah, we get involved in those things, particularly if you don't have a family that is relying upon the business and the income for the next generation. I've had some family businesses that are now in their fourth generation, but that's extremely rare.
Yeah.
Extremely rare.
Yeah.
Usually if it goes 2 generations, you're doing very well. But it doesn't happen by accident. It happens by good mentoring by the parents in bringing the kids in the business, recognizing the talents that they have and how they may best serve the business, and finding a succession plan so that they can get the business efficiently and with the least amount of taxes when they want to withdraw.
Do you have any recommendations for the businesses that started as a partnership, so they may have 2 or 3 different owners with different families on how they might want to begin considering what happens if something happens to one of the owners, what they should do to protect the other owners, and also the family of the either deceased or disabled,
Right.
partner or owner.
Well, I mean, we have represented businesses where I know, the owners get along, and they probably were best friends since they were kids, or college buddies, and they developed a business and was very successful with it. Both may have gotten married, had children, but neither one of them wants to work with the spouse when the one passes away. So in the organizational documents or in subsequent agreements, what we do for those owners is we have them enter into an agreement that says, hey, if I become, I hate to say become dead. If I die, if I die, or I become disabled, or if I no longer want to work in the business, or I get divorced, or have somebody levy upon my interest, you don't want to have a creditor take your membership interest, things like that. Right. Then the remaining partner will have the opportunity to buy that person out. Or let's say the person wants to sell to somebody else. What kind of rights does that remaining person have? Do they have the right to sell also? Or do they have the right to buy him out first, or right of first refusal, things of that nature? So those issues have to be addressed. Otherwise, you're inviting a real transition problem when one of those events happens.
I've seen businesses dissolved over that. Successful businesses with very happy partners in business or shareholders in the corp, it didn't matter as much, because what happened in the cases that I ran into that I saw were not planned for at all. So it's not that they were planned for incorrectly, they just weren't planned for at all. What happens if something happens to me? The discussion never came up. And one of the partners had died, which were brothers, as a matter of fact. It was the spouse, the wife. I think I might like to try this business out. And that didn't work out well. And within 2 years, the other, brother, this is it, I'm not doing this anymore. So the whole business caved. So now the spouse didn't get anything for the business, really, and neither did the other partner. I mean, it's a fiasco just because the discussion never came up. So you brothers and partners, sit down at lunch one day, just yourselves. Hey, what do you want to do if something happens to any of us? That's all it takes for starters, right? Right.
And then once you agree it's time to make a step, you should get a legal assistant or attorney help you out and draft the documents, because there's more options than what you think. Not only in terms of how you structure the buyout or the succession plan, but also how you fund it.
Okay.
A lot of these plans are funded with life insurance because you don't want to burden a business owner who survives a traumatic event by losing a partner or a fellow shareholder and having to pay, not only having to pay his bills and run the business, but also now pay a creditor for whatever half or whatever the value of that shares are. So it's a liquidity planning event too.
Yeah, and it's hard because you have two partners. One might be a great salesperson. The other's a great administration person, which is what makes the partnership work so well. And then you lose the salesperson. So now the business itself lost a lot of revenues, future revenues that the salesperson was, one was, hey, you stay out all you want and bring in new clients and I'll manage the clients, and it worked perfectly. So now, even if that spouse says, okay, I'll take cash. For half value. Where are you going to come up with the money? You just lost your best salesperson. You lost half of your income. You might have income it's a mess. So sometimes people and business owners will say, hey, let's insure each other. That's where you brought up the life insurance, where they'll say, well, that's cheap. We can afford it now while we're both living, while we're both active, while it's profitable for both. We'll buy life insurance now. We can afford the premiums. And then if something happens to either of us, it creates maybe $1 million that doesn't exist the day before we die. And presto, the spouse is cashed out. The other partner receives the whole business without any of the financial constraints. So I know where you're going, where you say there are a lot more alternatives and options available than you think. Get to an attorney like Matt, an estate planning attorney who knows how to help you evaluate through even discussions on what to do with this, and your lives can be a lot simpler by addressing these things in advance.
Oh, definitely. And, it will perpetuate your business. And this is something that, you've worked all your life, and you just don't want to see it pass away when you do.
Yeah, very good. Well, again, I want to thank Matt for coming in. I appreciate it very much for you bringing up these different areas that I know most of us, maybe we're so busy in our lives, and especially our working lives, we just don't have time to take a minute or two out to think about it, or we don't want to.
The don't want to is probably the bigger one.
Yeah, so I appreciate your coming in. Everyone,
Thank you,
I thank you for tuning in to another edition of All Things Financial. Matt, if you want to again share your phone number in case anyone wants to get in touch with you.
Sure, it's Matt Carl, 412-227-2500.
And again, appreciate all of you tuning in to another edition of All Things Financial. We'll be back again next week.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through Sage Point Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with Sage Point Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.